5 seconds to go. Start. The respondent plaintiff has relied upon the notice dated 13th February 2003 and evidences of PW2 and PW3 to prove that he was always ready and willing to perform his part of the contract. Stop. Even though it may be true that the respondent plaintiff had deposited the balance sale consideration in court on 6th April 2010, it cannot be ignored that such deposit was made by him 7 years after 15th March 2003, being the date by which the sale had to be concluded. Stop. No evidence has been adduced on behalf of the respondent plaintiff as to how the respondent plaintiff was in a position to pay or make arrangements for payment of the balance sale consideration within time. Stop. The courts below also erred in not adjudicating upon this vital issue except to make a sweeping observation that, given that the plaintiff respondent was a businessman, he had sources to arrange the balance funds. Stop. Careful study of balance sheet dated 31st March 2003 of the respondent plaintiff would demonstrate that he did not have sufficient funds to discharge his part of contract. Stop. Para. It is settled law that for relief of specific performance, the plaintiff has to prove that all along and till the final decision of the suit, he was ready and willing to perform his part of the contract. Stop. It is the bounden duty of the plaintiff to prove his readiness and willingness by adducing evidence. Stop. This crucial facet has to be determined by considering all circumstances including availability of funds, and mere statement or averment in plaint of readiness and willingness, would not suffice. Stop. Para. In this case, the respondent plaintiff has failed to discharge his duty to prove his readiness as well as willingness to perform his part of the contract, by adducing cogent evidence. Stop. Acceptable evidence has not been placed on record to prove his readiness and willingness. Stop. Further, it is clear from the respondent plaintiff's balance sheet that he did not have sufficient funds to discharge his part of contract in March 2003. Stop. Making subsequent deposit of balance consideration after lapse of 7 years would not establish the respondent plaintiff's readiness to discharge his part of contract. Stop. Reliance may be placed where this court, speaking through Justice S.B. Sinha, held that deposit of amount in court is not enough to arrive at conclusion that plaintiff was ready and willing to perform his part of contract. Stop. Deposit in court would not establish plaintiff's readiness and willingness within meaning of section 16C of Specific Relief Act. Stop. The relevant part of the judgment is reproduced below. Para. Deposit of any amount in the court at the appellate stage by the plaintiffs by itself would not establish their readiness and willingness to perform their part of the contract within the meaning of section 16C of the Specific Relief Act. Stop. Para. It is, therefore, patently clear that the respondent plaintiff has failed to prove his readiness to perform his part of the contract from the balance sale consideration of the suit amount. Stop.